Luke Dixon. I'm a partner and head of the data and information team at Freeths. I specialize in data protection and related matters. And I'd like to welcome you to this IHL update talk this morning, where we're going to be talking about some data, current data protection and e-privacy issues. So if we could just move on to the agenda slide, we'll see what we're going to be talking about today. And the first matter that we will be discussing is what's very much a hot potato, if you like, at the moment. It's the rather vexed question of international data transfers and the compliance with GDPR in relation to those, how you can go about doing those in a compliant way. And I think this is a subject that's particularly tricky at the moment and very very much current, because it relates to firstly issues around Brexit, which we will be discussing. Last year's high-profile European Court of Justice case in Schrems 2, which we will also touch upon. And if all that those levels of complexity were not enough, the prospect of new draft standard contractual clauses, which are also on the horizon, which the EU has also thrown into the mix. So in that section, we'll be talking about these background issues and how you might go about dealing with them, because I'm sure many of you will be considering how to deal with them at the moment, and also touching upon not just the theory, but also what the market appears to be doing at the moment in terms of strategies to deal with these international data transfers. Once we've come off that topic, I thought I'd also throw in a discussion around the ICO's new data sharing code of practice, which, as we see, is a useful guide, basically, to assist your organization's compliance where it's sharing personal data with other entities in certain situations on a data controller to data controller basis. So we're basically taking a walk through that framework as well. And as is customary on this talk, so we'll finish up with questions. So do please add some questions or put some questions into the chat functions as we go through, and I'll be delighted to deal with as many I can at the end of the session. And to the extent I can't actually cover all the questions, if we've got quite a few, be happy to follow up as well with you afterwards. Just before we move on to slides, as I said, we're going to talk about international data transfers, and I was just wondering, I think it might be a good idea just to have a quick poll, if you can, of the attendees here as to where they are, or what, how they're approaching their personal data transfers. So, are you currently transferring and receiving personal data internationally? Have you put in place measures to legitimize those transfers further to GDPR, Schrems 2, post-Brexit? So it'd be great if the attendees could just select their option, and we get, we'll take a look again at the results of the poll shortly, and we'll see where, generally speaking, people on the webinar are in terms of their planning for international data transfers and compliance issues around that. So moving on to the next slide, please. International data transfers and Brexit. I think GDPR and Brexit are obviously individually everybody's favorite topics, and when you splice them together, they're even more enjoyable to deal with. So where are we now following Brexit, apart from potentially on the verge of some kind of conflict with France in relation to Jersey fishing rights? Well, the Brexit transition period, as we know, ended on the 31st of December. And as a result of that, we know that the UK is now a third country for data protection purposes, and no longer is under the EU rules or data protection infrastructure. Having said that, we have proceeded to create and implement what is called the UK GDPR. The UK GDPR is effectively a piece of implements the European Union GDPR into UK law legislation alongside the UK Data Protection Act 2018, which we're familiar with and we've been working with for a few years now. So whilst we're sort of sitting outside of the EU's data protection infrastructure, we have taken legislative steps to align our laws with EU GDPR, as it's now called. So when it comes to UK and EU cross-border processing, GDPR and GDPR principles and requirements still apply, and we continue to adhere to those. Let's drill down into the approach that the UK and EU have taken to data protection matters in this post-Brexit era. So famously, we had the Christmas Eve agreement of 2020, the Trading Cooperation Agreement, and that agreement addressed some post-Brexit issues in relation to data protection. It didn't do so in any great detail, but there are one or two points which are quite significant, particularly when it comes to EU UK data transfers. So the first point is that the parties agreed to maintain a mutual commitment to high standards. So this sort of fits in, I think, with the legislative alignment which we've been pursuing with UK GDPR. The parties are basically saying that their respective standards for data protection compliance will remain at a high level. In addition to that, there was and a part of that, the parties agreed that there should be continued protection in relation to unsolicited marketing communications. That's kind of by the by for transfers, but feeds again into the idea of alignment, which is so important in this area. So the other thing, importantly, that the TCA introduced was a 4 to 6 month grace period to allow the continuation of EA to UK data transfers. The position prior to this grace period was that there was a free flow whilst we're still part of the EU, when we were going through that transitional period last year that permitted the free flow of those transfers. So this grace period basically continued it from the 1st of January to June. And the purpose of that was to permit the EU time to decide whether the UK was what we would call an adequate country to continue to receive data transfers from the EU. And when we say adequate, we basically mean the UK has adequate laws to provide protection to EU personal data. This all feeds back into the idea of alignment that I've been talking about previously on this slide. So the more aligned we are, the more likely we are to be deemed adequate by the EU, and therefore the more likely, should we get an adequacy decision in our favour, that these free flow of personal data will continue. Before I move on to the next slide, hopefully everybody's had an opportunity to respond to the poll. Dima, I was wondering if you can just tell us the results of that. Okay, so if you see the majority of people, 60% actually, well out in front, people are not really considered or put in place measures in relation to their data transfers and EU UK data transfers, but they are working on it. And then I think the next most popular options are, yes, we've identified the transfers, we've done everything we need to do to legitimize them, and don't knows also tie with that, and 10% of attendees haven't really started to think about it or indeed started working on it. That's and I think that's quite reflective of what I've seen as well, other clients and in the market generally. It doesn't really surprise me because, of course, we went through the transitional period of last year, and there was a possibility of the hard Brexit going out without a deal, and that would have, of course, encouraged businesses to try and get things in place in the event of a hard Brexit by the 31st of December last year. Okay, so if we can move on to the next slide, please. So in relation to Brexit, how should you handle transfers to and from the EEA? Well, let's take a step back first. As we know, we've we continue to align with GDPR. and certainly the EU retains GDPR, and GDPR has always restricted the transfer of personal data to non-EEA countries unless they are adequate. So, we are a non-EEA adequate country, and so there would be a sort of prima facie or first instance, restriction on transfers from the EU to the UK unless we get an adequacy decision in our favour. This, as I said, differs from the situation prior to the end of the transitional period, because we were part of the EU then, or part of the transition arrangements, and so we still had that nice, easy, free flow of personal data from the EU. But as we know, the UK is now a non-EEA third country. So what next? And as I said, until June 2021, we are currently under this grace period, and so for the time being, until June 2021, so not much time left, a month or so, you may continue to receive free flows of personal data from third parties in the EU. But then it really depends on what happens in June, whether we get an adequacy decision or not. So where are we with the adequacy decision? Are there grounds for hope, or is life about to get very difficult? And the good news, the tentative good news, is that a month or so ago, the EU issued a draft adequacy decision in the UK's favour, saying that the UK should be regarded as an adequate country for the purposes of receiving EU personal data. Now, I would say, obviously the caveat that it's still got one or two hurdles to jump in relation to the adequacy decision, and it is still a draft decision, but I think we can have a reasonable measure of confidence that we will get an adequacy decision in our favour by the end of the grace period. About a week or two ago, there was further development in relation to this because what is called the EDPB, the European Data Protection Board, which is kind of like the European think tank, if you like, in relation to data protection, issued an opinion on the draft decision in relation to GDPR compliance. And basically what that said was, okay, fine, we recognise that the UK is in quite a unique position when it comes to countries applying for adequacy status, because it used to be part of the EU and it's still closely aligned. That's a positive point in favour of adequacy. But it also identified one or two challenges, and those challenges it identified included the fact that the UK government has implied that it will try to move away in due course from GDPR and have a more bespoke approach to data protection. So the EDPB said, well, fine for the time being, but it's good that we've got we need to keep an eye on this, basically, in case the UK diverges further. And another challenge that it identified was in relation to onward transfers of personal data from the UK. So, initially the data is fine if the data going from the EU to the UK, but what happens then if it goes from the UK to a third country beyond that? It's still, so the issues around the levels of protection applied to those transfers. So I think where we are at the moment is, I think, as I said, we can have a decent level of confidence that we'll get an adequacy decision in our favour. I think the view is that the EDPB's opinion on the draft decision won't necessarily stop us getting an adequacy decision. It might possibly delay things slightly because of the challenges that it identified. But I think overall, I'm still reasonably confident that we will get an adequacy decision in our favour in June 2021, even if it goes slightly down to the wire. Next slide, please. So what does that all mean? So you're sitting in your organisation and you've got to sort of put together a programme or a strategy to deal with these EU UK transfers, and you're thinking, well, what do I do now? Do I start now? How do I approach things? So let's take the first easy point, really, and that is, say you've got data transfers in the opposite direction from the UK to the EEA. In that situation, you don't need to worry, because actually within a couple of weeks of the original Brexit referendum result in 2016, the UK government said that it would continue to permit the free flow of personal data from the UK to the EEA. So you don't have to worry about those transfers if you're doing them, at the moment, or as part of your, your international transfer, activities. They will look after themselves. So it is the EU to UK transfers that you need to think about. Now, although it looks like we're going to get an adequacy decision in our favour, we can't be 100% certain. The UK ICO, so it's the Information Commissioner's Office, it is basically the UK's data regulator, has issued guidance, I think relatively conservative guidance, but still quite sensible guidance in the interim, saying, basically recommending that organisations start to think about alternative measures put in place to legitimise their transfers if we don't get an adequacy decision. So basically, taking some steps maybe to deal with the possible eventuality that we don't get an adequacy decision. And the steps that it's suggested that people take, and that you may therefore consider taking as part of your program, is firstly to review and map the data flows that you get from the EEA. So who are you getting them from? Where are you getting them from? And once you've got that sort of map of the data flows, where they're coming from and maybe under which contracts and agreement, you can really then take the next steps. And those next steps would be to prioritize key transfers. So the key transfers are likely to be those transfers you get from the EEA or the EU, which involve large volumes of data or very sensitive personal data, or a combination of both. So, or it may be in more situations where the transfers are urgent. So be able to identify those and maybe deal with those up front. To the extent that we don't get an adequacy decision, you can also then consider alternative measures to legitimize those transfers. And when we talk about alternative measures, I think that the main alternative for transfers from the EU to the UK would be what we call standard contractual clauses, or SCCs. And these are basically a set of EU approved contractual clauses which you can append to an agreement, which provide for protections in relation to the personal data which is to be transferred. So basically, you could, the parties would enter into those SCCs and, as I say, append them to the framework contract which governs the transfers. So once you've done, considered, okay, we might need to do something else if we don't have an adequacy decision, then the last step, of course, is to implement. Now, that's all fine, and those are steps you can take, but you may well be sitting there thinking, well, do I devote time and resources to do this? And this is also a question that people are asking, when we bear in mind that the SCCs are due to be replaced within the next 12 months. So got a lot of things to consider there. I think the approach really is this. I mean, I've seen that a lot of businesses in the market across sectors aren't really taking any big steps forward towards dealing with their EU to UK transfers because they're hoping for an adequacy decision. I think to the extent that they are actually taking alternative measures, so putting in SCCs, it's where maybe they'd already undertaken a project to deal with the hard Brexit situation at the end of last year, and they've decided basically just to finish that off. And if we get an adequacy decision, fine, but they're already a long way down the track, and they might have as well have just put the SCCs in place just in case. Alternatively, you might still want to press ahead with putting SCCs or another alternative in place to legitimize the transfers where you've got a particularly urgent or particularly sensitive or high volume data transfer situation, and maybe you need to get it in place before the awaited adequacy decision, or if you want to make sure you're double bolted, if you like, in terms of your approach, in case for whatever reason we don't get an adequacy decision ultimately. So that's basically the approach that the practical approach that I see that organizations are taking across various markets. We go on to the next slide, please. So that's the impact of Brexit on data transfers, and obviously specifically data transfers from the EU to the UK. What about, there's the additional element or complexity added, is it's the Schrems 2 case of July 2019, or July last year rather. So this is basically a European Court of Justice decision, and it related to a court case that was brought in the Irish courts initially by an individual data privacy activist called Maximilian Schrems, an Austrian data privacy activist. And he basically took an action against Facebook. And the Irish case was referred up to the European Court of Justice. And his point was, or his case was, that the SCCs that Facebook were using did not provide his personal data with adequate protection when they were transferred out of the EU, in this case to the third countries, including America. And his argument was that if, say, the US authorities, surveillance authorities, want access to my data, there's nothing really in the SECs or what Facebook were doing to protect my personal data from that kind of intrusion. And so, as part of this case, the Court of Justice considered the SCCs and their validity, and it also considered the validity of what we call the US Privacy Shield. Now, the US Privacy Shield is an alternative means of legitimizing data transfers from the EU, or now would be the UK, to the US. And basically what it was is a self-certification scheme whereby the importing entity in America signs up to GDPR type standards. Now, the end result of Schrems was that the Court of Justice struck down a US Privacy Shield. So to the extent that you are part of, you've identified your data mapping, your transfers, and you know that you're transferring data from the UK, the EU to the US, you can't rely or use Privacy Shield anymore until such time as there is a replacement for it. The other thing that the Court of Justice said was, yes, the standard contractual clauses actually remain valid, so you can still use those. So that means you can still use them for transfers from the EU to the UK, and you can still use them transfers to non-adequate third countries elsewhere, but they're not necessarily suitable or adequate on their own, depending on where you transfer the data to. So basically, when using SCCs, if you're exporting data, you need to conduct a further risk assessment into the local laws of the country you're exporting to determine whether those laws will provide sufficient protection to the personal data once it gets there. And to the extent that that's not the case, you need to consider putting in supplementary measures alongside the SCCs in order to make them adequate to legitimize the transfers. So it's actually a very burdensome decision, really. So you now, in the old days, you just have your SCC and you'd be able to just sign up to it and then, comply with it, and it would cover and legitimize transfers. But now, because you're transferring to America, you might then need to think, well, do I need to put extra things in place? And it really depends on the results of the risk assessment, and that in itself is quite an onerous thing to expect organizations to do. Now, the supplementary measures come in 3 different flavors. So they can be technical measures. So you might put in requirements for the importing entity to encrypt the data when it gets to the third country. So if it's encrypted, then it's protected basically from access. In addition to that, you could also put in additional contractual clauses to the SCCs, and those clauses might say something like, to the extent that authorities in the US or whatever require access to this data for surveillance purposes or whatever, the parties will consult each other on how to deal with that and to minimize the exposure of the personal data to that kind of situation. And the last thing you can add in relates to organizational measures. So that's really things around about putting appropriate policies and procedures in place. So as you can see, it's quite a burdensome thing for organizations to have to do. And the impression I'm getting is that there's a kind of a safety in numbers approach here, that I think maybe the biggest organizations are starting to take measures to supplement their SCCs and do these risk assessments of third countries. But I think probably for SMEs, it's a lot more difficult for them to do that. And maybe they're not sort of embracing that approach as much, and hoping that it's just from a practical basis, they're not pulled up on it, basically. So we've been talking about the SCCs and having to put potential supplementary measures in place for them. Also need to just note and discuss the fact that the SCCs are expected to be replaced soon as well. So if we go on to the next slide, if that all wasn't enough, you're sitting there, you're thinking, fine, okay, right, I may or may not need to use an SCC, say from the EU to the UK, or from to America or whatever. I now understand that if I do use the SCCs, I might need to put in place supplementary measures. On top of all that, before you press the button on your program, you then have to also consider the fact that the SCCs, the current SCCs, which have been around since the mid-90s, are now due for replacement. So the EU has issued new draft SCCs to replace the current ones. Now, in the long term, I think this is a good thing, because as I said, the current SCCs have been around for quite a long time now, and they're actually still referred to the old EU directive. So it's good that they're getting replaced, and they do actually deal with some situations or issues with the old SCCs that were quite problematic. So firstly, they cover different transfer scenarios. So they can now cover potentially data transfers from processors to processors, or processors to data controllers, and they never did that before. It was controller to controller or controller to processor. So there are quite a lot of different types of data flow or data transfer that the old SCCs never really properly dealt with, and so it was difficult actually technically to legitimize those transfers. But that will now be dealt with. In addition to that, more than two parties can now sign up to them. So, you don't have to enter into a whole chain of these things like you had to in the past. And they also address some of the fallout from the Schrems 2 decision in relation to sort of supplementary measures as well. So in the long term, I think it's a good thing, and life will be easier when you want to apply SCCs in the future to a situation when you use these new draft ones. The EU is still consulting on the new draft SCCs. We expect them to be issued during this year, and hopefully soon. I mean, I think if anything, we'd expect them to be approved any month now. Once they've been approved, there will be a 12-month grace period. So basically, to the extent that you're relying on the current ones, you'll have 12 months to repaper them, to replace them with the new ones. So you get a bit of breathing space to do that. But I think if you're sitting here maybe considering using SCCs, again, I suppose it's really around a matter of the urgency of what you need to do, the sensitivity of the transfers, etc., as to whether you go with the current SCCs and then say, fine, we'll just have to replace them, but we need to do this now, or maybe wait just a little bit longer for the new ones to come into place. But these are all considerations, along with the adequacy decision and Schrems, that unfortunately the in-house council needs to juggle. So we move on to the next slide, and as a change of pace, we'll move away from the vexed question of international data transfers to the UK ICO's data sharing code of practice. So this is a new code of practice which the ICO has published at the end of last year. It is a statutory code of practice. So basically it derives from, I think it's section 121 of the Data Protection Act 2018. Basically said that the ICO shall issue a code to cover data sharing in certain situations. So first of all, you're probably thinking, great, okay, so I'm responsible for data protection compliance in my organization. I've got a lot on my plate having to deal with such things. possibly the last thing I then need is, a new layer of requirements on my organization to comply with data protection law. The good news actually with this code is it doesn't actually add any new barriers to processing. It doesn't add any new requirements on top of GDPR or Data Protection Act 2018. It is, I think, a very useful, and is intended to be a useful document to enable organizations to comply with what's already in place in terms of the legislation. So it's kind of helps, it's interpretive and guidance as well. What does it cover? What is the scope of it? So it doesn't cover every form of data sharing and data processing. What it does cover is regular data sharing or data sharing on a one-off basis. So it's agnostic as to how often you're sharing the data. It also covers data sharing in the sense not only of transferring data or sharing data between parties, but also just giving access to a third party to your data. And it also can cover urgent and indeed non-emergency data sharing. What it covers basically is data sharing between independent data controllers. So it's situations where you've got two parties who share a common pool of personal data, but when they share it, they're making their own decisions around how they process that data. What it doesn't do, or it's not intended to do, is to cover data sharing with say processors, so data processors. So that's covered by what you might be familiar with is Article 28 GDPR. And so that's basically the kind of situation where, say you're a data controller and you're appointing a service provider to process data on your behalf. It doesn't cover that kind of situation. That situation is still under Article 28. It also doesn't cover data sharing within an organization, although it could cover intra-group sharing if it's controller to controller. The last thing it doesn't cover is sharing between joint controllers. So those are sort of data controllers that have a shared pool of data and sort of have sort of joint decision making in relation to how that data is processed. In those situations, it's still very much, so you would process the data in accordance with the requirements of Article 26 GDPR. So we're talking about one species of data sharing, but it's a species of data sharing, controller to controller, which actually isn't addressed in a specific way or a prescriptive way under the GDPR itself. So it is useful to have this guidance to say, well, this is what you should do in order to make sure your sharing is compliant. So if we drill down into this, we move on to the next slide, please. So what are the key takeaways from the code? So basically, the first thing it says is that to the extent that your data sharing is going to be risky or present a risk to the individuals whose data it is. So it might be new technologies, for instance, or it might be processing data of vulnerable persons or data in a novel way that people might not expect. You should do what we call a data protection impact assessment, or DPIA. And that's basically an assessment document that you can enter into with various stakeholders involved in the data sharing project to identify any risks in relation to the data sharing, and then to basically introduce mitigations to bring the risk down to an acceptable level. Another thing the code says is good practice to do is to have a data sharing agreement in place. And this is what I now see, generally speaking, that where there is data sharing, even controller to controller, clients do enter into some kind of data sharing agreement. It could be for, the more low volume, low sensitivity sharing, might maybe just be 2 or 3 clauses in an overall commercial agreement. But it might actually be something that's standalone and a lot more comprehensive in data sharing, which is high volume and high sensitivity. But the good thing about the data sharing agreements is that you can impose protections on the data and obligations on each other in relation to the sharing. and that will also provide a structure to your sharing as well. As you might expect, the code said that where you're sharing the data, you need to comply with UK GDPR data protection principles. And so those are the principles that you may well be familiar with, generally from all kinds of data protection compliance perspectives. So that will be things around being fair and transparent in processing the data, securing the data, things like that, basically. To the extent that I don't know, the extent we have public sector organisations on this webinar, but another thing you need to consider is whether you have a legal power in the first place to share the data. And the code also discusses a key principle of GDPR, which is accountability. It's very important in this cornerstone of GDPR to be able to demonstrate to the ICO, the data regulator, that you have been compliant in the way you process your data. And the code suggests ways in which you can do that. And that's things like keeping an audit trail in relation to the sharing, and also getting your data protection officer involved in the project to the extent that you have a DPO in place. As we've seen, it's important to keep the data secure, and also important to have policies and procedures in place for dealing with things like data subject rights requests. So that's things like data subject access requests or right to be forgotten requests, etc. But also dealing with personal data breaches, so identifying them, recording them, and reporting them to the ICO or to individuals as applicable. So these, where you're in a situation where you're sharing data, we were sort of talking about data sharing agreements. I always think it's a good idea to have in place obligations on the parties to cooperate with each other. For instance, where one party receives a data subject access request, or where one party experiences a personal data breach in relation to the data they're sharing. So the parties can sort of make each other aware and cooperate in relation to that to the extent necessary. And that can really help manage down the risk of the parties in relation to their data sharing and processing. It also recommends that where you're sharing data, you do your due diligence on the data that is being shared, and that's the kind of thing that's particularly relevant to things like M&A transfers, when you might be acquiring personal data as an asset in a deal, and also in relation to databases. We're going to go on to databases and the issues in particular around that shortly. And the last thing that it also mentions is, to the extent that your organisation is processing and sharing children's data, and you're in that kind of sector, there are also special considerations around that. So, children's personal data doesn't attract, special requirements under the legislation per se, but the code does recognise that children are potentially vulnerable people, and you need to approach the sharing of their data in a way that always has their best interests in mind. And your privacy sharing, your sharing needs to be set to a sort of a high privacy standard as well, in relation to things like transparency issues, lawful basis, etc. In order to ensure that you are looking after the children's data in a way that does meet the children's best interests. So moving on to the next slide. I mentioned databases, and this is an issue that comes up quite often actually in things like commercial deals and in M&A deals as well, and it's brought out to have specific, particular focus in the code, the sharing code. So say your organization wants to acquire a database. I mean, that will be data sharing, and so the parties will have compliance obligations under data protection law when they transfer and indeed receive the data within that database. So they should be considering the code when they're doing that sort of thing, and then the code could give you a useful framework for compliance. So we mentioned due diligence. If you're acquiring a database from a third party, you should be doing your DD to ensure that the integrity of the data you receive is adequate, and it's not going to get you into trouble once you've received it and you started processing the data in that database. So what kind of diligence should you be doing? Well, the code suggests you should be looking at things like, what the data subjects were told, and the data subjects will be the individuals whose data is in that database. So it may well quite often be a marketing database, for instance, with their contact information on there. So, were these people told that their data was going to be sold as part of a database to a third party? If they weren't told that might have issues for transparency and maybe lawful basis and fairness around sharing the data. Is there a lawful basis for collecting and sharing the data? As with all forms of processing, you need to be able to identify that the transfer of the database to you has a lawful basis under GDPR. Quite often that might be, say, legitimate interests in M&A transactions, for instance, but there might also be other considerations at play there. Consents is always a big issue, particularly if it's a marketing database. You need to check that the consents that individuals have given are adequate for you to be able to use that database. So, quite often you have situations where maybe the individuals on the database have consented for their contact details to be used to contact them with electronic marketing, and that might apply to the original organization which collected the data and put the database together, but those consents won't necessarily cover yourself if you're receiving that database, you've acquired it. So you might find yourself in a situation where you've got a useless database because you can't actually contact these individuals because you're not consented. It's not adequately consented in your favor. And a further consideration is basically relates to one of the key principles of GDPR, and that is data minimization. Is the database adequate and relevant to your needs, or is there more information in that database than is actually necessary for your purposes or the purposes for which you're collecting the data? If it is excessive, then again it won't be compliant under GDPR. So what happens when assuming that that's all fine and you've agreed to transfer the database over, what should you be thinking about once you've received it? And if you receive it as basically an asset, you need then you will become the new data controller of the database, and so you will need to tell the individuals whose data is on the database that you are the new controller, basically, and that you will be processing their data. So that basically normally involves issuing a notice as soon as practicable following the receipt of the database to tell them that and say, hello, we're the new controller, provide them with the usual sort of GDPR privacy policy information, and then so you can then proceed to process their data. The last bullet point I've got there on the slide notes the interaction with privacy regulations and direct marketing rules, and this really goes to the issue of consent that I mentioned before. So you've got sort of two areas of data protection law which are relevant here. The first is the one which the code sort of covers, and that's GDPR compliance and all the GDPR principles. Have you been transparent about the process? Do you have a lawful basis for transferring the database and processing the data? But in addition to that, this relates to the consent point, under things like the privacy regulations, if you're going to then use the contact information to contact people, you may often need opt-in consent in order to do that. And so you can see that GDPR and these privacy regulations overlay onto each other to apply to this sort of scenario. So again, the code says it is about, obviously, a lot about GDPR compliance, but it's not just about that when you're basically processing database personal data. So move on to the next slide, please. What about enforcement? So how will the ICO enforce the code? Basically, as I said, what the ICO will do is to use the code now to help assess compliance with UK GDPR. So, it's the kind of thing you'll look at to say, look, did they do X, Y, Z under the code when they were data sharing? And if you didn't, and it's less likely that you're going to be able to demonstrate that your data sharing was compliant. So again, this goes back to the idea and the point that I was making earlier about it being a useful kind of checklist really for your data sharing. And as with, its enforcement in general, the ICO will take a fair and proportionate and timely approach to its regulatory action. And it has the power to take certain enforcement actions for breaches of UK GDPR. And those enforcement powers include, assessment notices, enforcement notices, all the way up to the dreaded fines, which have sort of pushed GDPR and data protection law, to sort of board level as an issue. So, the 17.5 million or 4% of global turnover levels. So that's, it also gives you an idea of the ICO's approach to how it would use the code in order to express its enforcement powers and approaches. So the code has basically been published and it's going through a parliamentary process. We'd expect it to be formalised and issued shortly this year. So do keep a lookout for that as well. As I said, if you're entering into controller sharing, particularly if it's the more complicated and the high volume type of sharing, I do recommend looking at the code of practice before you enter into that sharing, because it will be a useful document for you to help you demonstrate compliance. Okay, if we move on to the next slide. And we're at the questions, and I think we've got some questions here. I think just a couple of housekeeping points. I think before we finish, we've got a couple of queries. Are you recording this session? And yes, we are recording this session, so we will be able to issue the session to you afterwards, and also be able to follow up with any queries as well that we might not be able to deal with now. Got a question in relation to data transfers from the UK to non-EEA countries such as the USA. Do we have recommendations for protective measures relating to data flows for businesses to take, particularly since Schrems? And I think really that's also a great question, very practical question. I think this probably goes back to the measures that we were talking about earlier on in the talk, and I think they probably fall into three main flavors. They are the technical measures you can take. And this is in relation to, say, SCCs. So it's, I think it's likely that you would be looking to legitimize your transfer from the UK to the USA via SCCs, because you can't use US Privacy Shield anymore. So you'd use the SCC. I think you probably then determine whether you'd be using the current one, or you can keep your powder dry to the new SCCs come along. And then to the extent you're using certainly the current ones, you need to do some level, I think, of assessment in relation to supplementary measures. And as I said, those measures will come in three flavors. It will be technical measures to protect the data. So maybe encryption, for instance. Extra contractual terms you can put in to supplement the SCCs. Around sort of dealing with the local law authorities' invasions, if you like, into the personal data that's being transferred, and also any policies and procedures, organizational measures you can put in place. But these considerations will all revolve around really the third country to which you're going to be sending the data, and really the nature of the data transfer itself. So it is quite tricky and quite onerous. You might take a pragmatic approach to it if actually the transfer is quite low level and low volume, etc. So just see if there are any other questions. I've also got a question in relation to the SCCs themselves, where we are with the current SCCs, and should we be using the new ones instead? Well, I think sitting down now, if I was approaching the use of SCCs to legitimize transfers, we're still waiting for the new ones to come through. So clearly we can't use those right now, albeit it will be quite soon. Again, I think I'd probably be looking at the type of transfers that I'm doing and working out their urgency and sensitivity before then deciding whether to go with the current draft SCCs. And if I decided that, yes, it would justify even for a short-term basis using the current draft SECs, I would proceed to do so. And I think I'd just be biting the bullet really for those more sensitive high volume transfers to get them repapered to incorporate the new SECs in due course. And it kind of depends really. I suppose if you've got lots and lots of flows, it might be only a crumb of comfort that you've got 12 months grace period once the new ones have been introduced to repaper. It could be a real headache. But on the other hand, if you're relatively traveling relatively light on this issue, then it's not going to be such a big deal really. And you say, fine, I'll use the current ones and then I'll just repaper in 12 months time. It's only a couple of the more important transfers. It's no big deal from a repapering perspective. So I think that's questions I can see for now. I think we've also basically more or less out of time. I'd just like to say thank you very much indeed for your time and attention this morning. It's been an absolute pleasure speaking to all of you, and I hope it's been a useful insight into, so when it comes to the data transfers, arguably the most complicated data protection issue that businesses are faced with at the moment. So if you do have any sort of further queries, or you would like support on your data transfer projects going forward, please do reach out to myself or the Freeths team, and we'd be delighted to talk to you about it. And I also hope that the section on the data sharing code of practice has also been a useful insight into how that document can help your data sharing projects going forward. So thank you very much indeed, and have a great day.